The First District Court of Appeals now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case scheduled for oral argument this morning. The case of Philip Morris USA, Inc. versus Elaine Jordan. Is counsel ready to proceed? You may approach, Mr. Michael.
May it please the court, Jeffrey Michael for Philip Morris. I would like to reserve 5 minutes for rebuttal with the court's permission.
So noted, Madam Clerk. You may continue, Mr. Michael.
Now, this is an appeal of a fee and cost award in an Engel progeny case that arises out of Duval County. The trial court's adopted rates of up to $950 an hour were excessive due to its erroneous legal decision to base rates on those charged by non-Jacksonville counsel in other Engel progeny cases. It's obvious that something went wrong with the trial court's analysis when you have counsel for plaintiffs charging $500 an hour as a standard civil commercial rate in 2015, which is the relevant date here, yet receiving $950 an hour for work on this Engel progeny rate case. And you don't need to dig into the record to find that information. It's right in Appellee's brief at page 19 that in 2015, the standard rate for Mr. Mills was $500 an hour, yet he was compensated for $950 an hour.
Counsel, then, why is it unreasonable to consider Engel litigators as a group when evaluating the market rate for such cases, as opposed to only considering the market rate in Jacksonville?
It's not unreasonable to consider Engel litigators' rates, but you should consider Engel litigators who are from Jacksonville. The record was not that there's no Jacksonville based Engel litigators. You have the Khalil firm, who is one of plaintiff's firms in this case, in Jacksonville. You have plenty of other law firms doing Engel work in Jacksonville, but the Khalil firm lawyers were compensated as if they were from Washington, D.C., or Chicago, or New York City, or even Miami. You also had defense counsel in this very case from Smith, Kimbrough, and Russell in Jacksonville. The problem first, it's contrary to the governing law that you go outside the local market to set rates, but just from a logical perspective, other markets have other market forces, have other overhead for their lawyers, different costs, and it's just apples and oranges. And when you compound that with looking at defense counsel's rates, you've got different, usually you have different drivers from the defense side where a client might want to use national counsel who faces many, many cases.
I have a question. Why would it be proper to categorize Engel as a class unto itself as sui generis? Shouldn't the trial court have simply ordered fees based on complex civil litigation?
That's exactly our position.
In fact, aren't Engel cases easier to prove than other types of cases? Remind us of what elements a plaintiff does not have to prove in an Engel case.
Well, it's essentially all of what you would call the wrongful conduct elements. So when you start with negligence and strict liability, it is instructed to the jury that defendants were negligent, that their products were defective. So what you have left is essentially medical causation, that smoking the defendant's products causes cigarettes and damages. And the fraud, the jury is instructed that essentially there was a fraud and reliance is yet.
Right, and before this court issued 2 opinions, but I think in 2015, a plaintiff didn't even have to prove detrimental reliance to show fraudulent misrepresentation, right?
Well, there were certainly courts that were allowing.
They didn't have to prove individual reliance until this court issued 2 opinions, at least in this district, that you do have to prove individual detrimental reliance.
Right.
So you didn't have to prove detrimental reliance. You didn't have to prove negligence, correct?
Correct.
And one more time, remind us what else you didn't have to prove?
You didn't have to prove defect in the product, and you didn't have to prove the other
So in
fraud.
fact, if you want to call Engel case a sui generis, in a sense, there's less of a burden on the plaintiff, right?
Absolutely.
But
So in that
nonetheless,
sense, you would award a lesser fee.
That certainly was our position at the trial court.
But nonetheless, defense spent $3.6 million defending this, apparently, so why is, in the grand scheme of things, 3.2 unreasonable?
Well, first, that's not the proper comparison to be made as a legal matter, and just as a logical matter, like I said, defense side often has different drivers of the costs. For example, defending statewide or national litigation, you might want to spend more money to get, there's some case law that says, just because the defense spends for a Rolls Royce doesn't mean that the other side gets compensated.
Didn't the Supreme Court in Patton indicate that that was a reasonable consideration?
Well, the Supreme Court in Patton indicated that discovery of opposing counsel's hours were allowed so that perhaps if there's a challenge to reasonable hours, they could be compared to see, well, you spent 3 hours doing this, they spent 3 hours responding. Patton actually doesn't speak directly to rates or total spend.
On the row factors, there's a number of different factors. The customarily charged in the locality for similar services is but one of the factors. Given that it's an abuse of discretion standard, if the trial court, say, abused its discretion on that factor but got the other factors right, is that reversible? Or do we look at the grand scheme of the fee award, or do we look at each individual factor?
Well, I have a couple of responses. Well, first, yes, that would be an abuse of discretion because you have the trial court making an erroneous legal ruling while exercising its discretion. But in general, that factor is the most important factor. That's essentially the baseline that gets set is the prevailing market rate, and then it gets bumped up or down by the other row factors.
I mean, the trial court here basically said, I'm not going to follow the law, and I'm not going to apply the prevailing market rate.
That's
Right.
That's right, based on the finding that Engel is sui generis.
Right, and there's no legal rationale for that based in existing law, is there?
No, and the trial court did not explain what he meant by Engel being sui generis.
Why shouldn't Mr. Brown's testimony be considered competent substantial evidence that supports the trial court's award of fees in this case?
Ms. Brown?
Mr. Brown, Mr. Edwards, excuse me.
So you had an expert for plaintiff's counsel that was basing his expert opinion on the exact same flawed methodology that the trial court adopted, which is that Engel is sui generis, that you can't look at general Jacksonville rates. He himself was charging $650 an hour. He's a very long-standing, accomplished lawyer, and he said the highest he'd ever charged in his career was $650 an hour. So you have, to the extent that you're falling back on expert testimony, it suffers from the same flaw that the trial court's analysis did. I would also note that Mr. Edwards had testified in a prior fee hearing to these same rates, and he took into account factors that I think even now are agreed are off the table, like the results obtained and contingency factor and things like that. And the trial court said, well, that methodology is wrong. And so he changed his methodology in this case to comply with that, yet still using non-Jacksonville rates. And he didn't change his figure by a single dollar. So he's just changing his methodology, still not compliant with the law, yet reaching the same rates.
I mean, here, as I recall, it's approximately 4,000 hours, and the award was 3.2.
That's right.
So it's basically an overall award of $800 an hour.
Right, we've cited...
If you combine all the lawyer's time.
Right, and we cited the blended figure in our brief for the defense side, which was about half of that, or less than half of that.
You mentioned contingency fee. That was one of the factors under Roe, and I think Appley argues that as kind of a tipsy coachman argument. Is that not a valid consideration now under one of the Roe factors, that this was a contingency arrangement?
No, the contingency can't be taken into account in setting rates.
What case says that?
Well,
Past Roe.
So you've
That's
got...
under 76869, right?
Well,
You cannot apply a contingency multiplier under an offer of judgment award.
But I'm not talking about a multiplier. I'm talking in determining a reasonable hourly rate under Roe. One of the factors that Roe listed, of course, that's a old case from '85, but one of the factors they listed was the contingent nature of the action. not a multiplier. Obviously, I agree you can't get a multiplier on a 768 fee, but why is that wrong? What has changed since Roe that's come out?
So you had Sarkis that said you can't have a multiplier, and changing the rates based on contingency is essentially a backdoor multiplier. And I would point, Your Honor, to Skinner's wholesale nursery case, which is from this court in 1998. It was an eminent domain case where a multiplier is not allowed, and this court reversed the trial court for taking into account a risk factor on rates, which was also called results obtained, and said it is clear that the contingency risk factor operates as a multiplier, and reversed. So I would say here that will be doing the same thing. It will be contrary to Sarkis to use contingency to bump up rates. It would act as a multiplier.
Speaking of Brown, counsel, was this issue litigated on appeal in the Brown appeal?
The legal principle, it was part of the legal principles that were urged for reversal in Mary Brown. The factual record is somewhat different. We have our rates at issue, and we've provided them in this appeal, so that the facts of this appeal, that our counsel's rates were even lower than the trial court
And there was no
awarded.
discussion of the issues in Brown.
Right,
Our
and certainly there was.
Our
it's-
opinion declined to provide any analysis or rationale for its affirmance, correct?
Right, it's the equivalent of a per curiam affirmance, so it's certainly an open issue for this panel. I see I'm into my rebuttal, so I'll reserve.
Before you sit down, counsel, as to appellee's request for appellate fees, why do you suggest that we should remand the issue of entitlement to fees under Markowitz to the trial court?
Remand the issue on entitlement to fees for litigating amount of fees? in
Entitlement
this
under the
appeal?
Markowitz opinion.
Right, so the Markowitz opinion would say that they can't get fees for this appeal. If they wish to create an evidentiary record to potentially preserve that issue for the future, I'm not going to say that they shouldn't be allowed to preserve that issue. They've attempted to raise it, so this court could deny, but I'm not going to be opposed if they want to go back down and try to create a record for a second appeal.
Thank you, counsel.
Good morning, and may it please the court. John Mills on behalf of the appellee. The relevant date is not 2015, it's 2019. That's what the trial court found. Same reasoning as in Mary Brown. That's not been challenged in this appeal. It was there, and it was addressed in the opinion. So 2015 rates are not relevant. This is sui generis, and there's two reasons. First off, the record in this case. There's competent, substantial evidence to support the trial court's finding, which was not an abuse of discretion, that these cases are different. That evidence was the detailed testimony of the expert, Tom Edwards, who is a very highly respected products liability lawyer, who testified that products liability lawyers in Jacksonville and elsewhere like him, many of them early on declined to get involved in this litigation because it is so difficult. I'm going to address the legal issues which were raised here in a minute, but it's not just the legal issues. It's the way these cases are tried. The defense in these cases push every issue, make you work everything, discover new angles of the law you've never even thought of, brief everything. You see 30,000-page records, as in this case, where there was only one trial.
But, counsel, have there been any other instances, other than Engle cases, where the courts have looked to the type of case in establishing the market rate rather than focusing on the actual locality?
Absolutely. There's plenty of cases that say you look at, and it's from the rule. The rule says you're supposed to look at, and let me back up. This is one factor out of 15. They do not oppose 14 factors. So we're only here about one factor. Even if we're wrong, the totality of the factor supports this award. But the factor that we're looking at, Judge Lewis, says charged in the locality for legal services of a comparable or similar nature. So that was the judge's job here, was to determine what is a comparable or similar nature. And yes, Judge Thomas, at first blush you could say products liability, that's what this is. But it's not. And in fact, we've litigated that issue as to whether this is a products liability or a fraud case involving comparative fault. There were splits among the District Court of Appeals. We had to go to the Supreme Court. Some of it
Well, you're
depended-
aware of the criticism of the Engel decision, I'm sure.
Certainly,
And the
I am, and this
criticism of
court
that-
has called it.
Let me finish my question.
I'm sorry, absolutely.
And the criticism is that the Supreme Court in the Engel case, and I believe the issue is pending now in the Supreme Court, created a body of law that essentially provided an easier path for plaintiffs to recover by eliminating the burden of persuasion on certain elements. And in fact, until our opinions on detrimental reliance and the other districts, which disagree, I know, say you don't even have to prove individual detrimental reliance. So I understand that 4,000 hours were billed here, and I've read tobacco records personally, so I know how complicated they are. But the idea that this is somehow a harder type of legal case to litigate, doesn't that seem to contradict the fact that Engel plaintiffs were provided an easier path to recovery by the Engel decision?
No, it doesn't, for two reasons. The factual reason is the way they are defended and the way you have to try them, the amount of time and effort, and you have to go 7, 8 years before you get paid. That's why this record shows most products liability lawyers don't do it, and why we look at this smaller group. That has nothing to do with the complexity of the legal issues. That's just how they're tried. And courts, we've cited Judge Soud and Morozic, Judge Terrell and the Panhandle, New Jersey Supreme Court, the Patton quote. It's replete. Courts have recognized this is sui generis, particularly because the way these are tried. They don't let lawyers out of cases when they say, I got in too deep, so lawyers don't come into the cases. As to the complexity of the issues, there's splits on all of these issues. And respectfully, Judge Thomas, you're not correct about reliance. In this district, reliance has always been required. I filed multiple cross appeals that this court rejected, saying we don't have to prove reliance on a statement. Everybody's agreed we have to prove reliance on the concealment. The question, and there's a split, this court there's a certified conflict, it's before the Supreme Court, as to whether it's not just reliance on an omission, but reliance on a statement that omits something.
That's what I'm referring
So that's
to.
heavily litigated, and to litigate issues like that, and the issues...
But until our opinion came out saying that you do have to prove detrimental reliance on a statement, the state of the law, and it's still the state of the law in the other 4 districts, is that you don't have to prove it. You can just prove it by the massive advertising.
Well, there was no
Is
law.
that not
in this,
true?
There was no law from this court. The trial courts were split on that issue before this court ruled in
Right.
Prentice.
And I know that's pending in the Supreme Court, but
Sure.
But
and that's
again,
not an issue in this case. But if you look at
Right.
if you look at the issues in Jordan, the appeal, they were very complex, unique to this particular kind of litigation. There was an issue about the admissibility of some evidence. It went to manifestation on the class membership date. Did this disease manifest by November 24th, 1996? What does manifest mean? And there was a split there in the district courts. We tried this case before it was resolved. It was ultimately resolved by the Supreme Court in our favor, and that rendered that evidence.
And I don't
moot.
think I don't think any reasonable person would argue these are not complex cases.
The comparative fault.
Let me finish.
I'm sorry.
As I've said, I've read the records in these cases. They're incredibly complex. You have very emotional testimony. You have devastating testimony. You have expert testimony. However, the fact of the matter is that Engel plaintiffs have been relieved of the burden of persuasion on several elements. In other products liability, you're not. You mentioned the length of the case and how long it takes to get paid. But post-judgment interest covers that problem.
Well, it does. And also we have appeals like this one where we're going to spend 10, 20, 30 hours arguing over $500 of costs. The cost issues in this case are 1%, less than 1% of what we're talking about. It's because there's a deliberate strategy by these defendants, well documented by courts across the country, to make these as expensive to litigate as possible for the particular reason of dissuading plaintiffs' lawyers from ever taking the cases. That's recognized by courts across the country. We've cited it. Judge Corrigan in Jacksonville, in imposing sanctions on a plaintiff's lawyer, talked about all of these things and why this is sui generis, and there are few lawyers that will take these. And so these are considerations. You may disagree with them. I understand that you do.
Counsel, the issue in this case is not the complexity of the case, but the amount of fees awarded by the trial court.
That's correct.
Is it your position that the courts are permitted to consider the contingent nature of a fee in determining an hourly rate? If so, how do you reconcile that with Roe?
Well, first off, that is my position, and we argued that to the trial judge, and the trial judge says, I don't have to answer that because these rates are sustainable without that. As did Tom Edwards, the expert, in both cases. He said he wasn't saying this is a reasonable rate. He's saying these are the rates that are demanded by the plaintiff, and I've analyzed them, and they're reasonable. If I were setting the rate and telling you what the highest reasonable rate is, it would be much higher. That's his testimony. And so it's a moot point, but it is, as Judge Bilbrey said, it's a tipsy coachman argument here that it ought to have been considered. And we ought to have gotten an even higher rate. We've been paid a higher rate. In the Sykes case, R.J. Reynolds fought us until the end and then voluntarily paid us. It's the only one of these, you don't see these for a reason, okay? This happens in every case. Well, if you settle fees, you usually have a confidentiality provision. So you don't know what's happened, and we can't say. But we do know in Sykes there was no confidentiality provision. In Sykes, R.J. Reynolds paid me $1,000 an hour. They paid the rates we were seeking, which are $50 more than what the trial court awarded us. And the reason that it should be considered, you do not get a multiplier. Sarkis is the law. We don't get a multiplier. You don't take the reasonable rate and multiply it by anything. But and so the cases that say we don't consider the contingent nature and the rate when we're doing a multiplier don't apply here, because if you don't consider it here, then you're not considering it for any purpose contrary to the rules the Supreme Court has said applied. And the Supreme Court has explained in the Bell case that a contingency fee lawyer has to charge more. And in fact, in this case, most contingency fees are a percentage. We had 40%. So Ms. Jordan has paid us more than we're seeking here today. She's not getting back the reasonable attorney's fees, reasonable under the bar rules, that she's paid us, because the case law says we have to go lodestar. Okay? But here, my firm, and there's ample evidence in here, we will do cases for an hourly rate on a contingency basis for the same rates we're seeking here, and we've been paid them. In Engle cases and even in non-Engle cases, this record has competent, substantial evidence supporting our rates in a number of cases where we have charged and been paid exactly these rates. There was an Arimi case, was paid $10,000 a day even when I only worked 9 hours. Not contingent at all. That was just an hourly rate in an Engle case where I was hired because the appellate lawyer who was going to handle it couldn't handle something for trial support. So that's in the record in this case. We've voluntarily been paid this by clients and by an opposing party who has every incentive. They've got no loyalty to us. It's one thing for a client to say, well, I love my lawyer, I guess I got to pay him. R.J. Reynolds doesn't love me, but they paid my rate because they know it's supported.
Counsel, you haven't addressed the second issue as to the costs awarded by the trial court. What evidence in the record supports the reasonableness of the flights of Doctors Wright and Frazier as taxable costs?
Well, the actual costs were presented, and there was no argument or evidence offered that there was any lower airfare available for them. There was no evidence by Philip Morris whatsoever. They just objected and said, well, that's unreasonable. And we testified that we paid it. There's evidence that we paid it, and there's zero evidence that you could find a cheaper cost of getting there. There's none. It would be one thing if they had put on that evidence and said, well, why didn't you get an economy class for Dr. Wright?
I think we could take judicial notice that it's hard to do legal work on an airplane, and if you're flying commercial.
That was my other point. Absolutely. Flying coach from L.A., reading transcripts.
Doesn't work.
It doesn't work. There was no evidence presented by them on any of the cost issues. We put on our evidence, and they just had footnotes and a memorandum saying, well, that's just too high. And if you look at their actual arguments, their arguments were these aren't authorized by the guidelines. And to give something that's not by the guidelines, you have to make findings. But they're both authorized by the guidelines. They're directly authorized by the guidelines. The guidelines authorize reasonable travel expenses when traveling in excess of 100 miles from the expert's principal place of business. So they authorize reasonable. They didn't have any evidence that these weren't reasonable, so this is right in what's authorized. Same with the retainer. Guidelines say a reasonable fee for deposition and or trial testimony and the cost of preparation of any court-ordered report. The evidence here was that Dr. Proctor, who was the only expert available, the testimony is there's no other expert that was available for this trial, that he requires, his fee is $10,000 flat and then an hourly for while he's in court. And so that's what we got. And again, Judge Thomas, you are right. Mary Brown is no precedential value. Neither does Clayton. But in Clayton, this court affirmed these exact costs. And this is in the record in this case. We showed Judge Healy that they appealed this already once to this court, first-class airfare and a retainer fee. And this court affirmed it, didn't address it. So that's not precedent. Neither is Mary Brown. But it shows an abuse of discretion standard when a trial court is making the same ruling that other trial judges have made and that judges on this very court have said was not unreasonable. That's evidence of it's not an abuse of discretion.
Well, as to Dr. Proctor, my recollection of the record is there was some testimony as to the necessity there. Was there that testimony as to Frazier and Wright?
There was no testimony regarding their airfare. It was just what it was. This is what we paid. And again, that's a prima facie case. That's what it is. If you want to say it's unreasonable, put on some evidence. They have no evidence to support it. Certainly the evidence that we paid it is competent, substantial evidence that it's reasonable when there was nothing given to the contrary below.
Counsel, as to your request for attorney fees on appeal, is it your position that we cannot or should not determine whether Markowitz applies to appellant fees and should instead remand the issue to the trial court?
Well, I don't think you need, Markowitz applies. It's a binding first DCA decision. But we still get appellate fees for entitlement issues, okay? Even under Markowitz. And we have an appeal about entitlement to costs. That's what I was just arguing about. So we're at least entitled to that. So there's got to be a remand for the fees on that. And all I'm asking is that we be able to make a record in the trial court to show. I think this is the poster child. We have a case where this court has already affirmed. We talked about this case in Mary Brown. I said, we got another appeal coming. It already affirmed this, and yet here we are. We're incurring more and more fees. And we ought to be able, the plain language of the statute says we get all our reasonable fees, and there's no way to read around it. But the courts have done that. And so we want to preserve that, and we want to bring that to the Supreme Court of Florida, which we think will follow the plain text of the language. So that's why we asked for the remand. The only difference they say between Mary Brown is that their lawyers were paid lower rates here than the lawyers who tried Mary Brown. But there's no evidence to compare the lawyers they're talking about to our lawyers. The only comparison we have is to Amir Tehrani, who the testimony was mine, that he and I are peers. We're very similar, except for I have a year more experience than him, and he charges $100 more an hour than we even sought. That's competent, substantial evidence to support the award in this case, and you should affirm. Thank you.
Thank you, counsel.
First, I want to clear up the 2019 to 2015 rates issue, or which date the trial court used. What the trial court said is different than Mary Brown was, well, here I don't really need to decide whether to use 2015 or 2019 rates because the evidence is that they've remained the same for plaintiff's counsel during that period of time, which was part of what I said. Dr. Edwards changed his methodology between the cases but didn't change his bottom line rates. But even if you wanted to use the time of the fee hearing, again, go to plaintiff's answer brief at page 19, and Mr. Mills says his standard rate at that time was $700 an hour, yet he's getting $950 an hour here. Amir Tehrani billed something in the order of 10, 15 hours in this case. He was not actively involved in the case. We've given you our first shares rates, which were hundreds of dollars lower, our second shares rates, and our what we call a third chair, or the lawyer presenting argument to the court's rates. All of them were hundreds of dollars lower than were awarded here. We've also provided your honors with the Gore opinion from down in Indian River County, where top-tier Engle lawyers on plaintiff's side were awarded $400, $500 an hour. This is certainly not something that you can just say, well, R.J. Reynolds settled a case where they didn't want to go through discovery, or for whatever reason they settled a case and use that against Philip Morris. And in that settlement, in the court order, there's not a blessing of specific rates for plaintiffs' counsels. They didn't agree that Mr. Mills was $1,000 an hour. On the legal principle, Roe directly says that in establishing this hourly rate, the court should assume the fee will be paid irrespective of the result. That means no contingency, and take into account all of the disciplinary Rule 2-106 factors, which is now 4-1.5, except the time and labor required, novelty and difficulty of the question involved, and the results obtained, and whether the fee is fixed or contingent. So why did he do that? Saying this was a hard case to litigate goes to hours. It does not go to rates. It means you had to spend more time. That was complex. It means you had to spend more hours drafting briefs, more hours preparing. If you put it to rates as well, you're double dipping. And that's why Roe and Joyce and a whole bunch of cases say that those factors are not allowed with respect to rates. Just 1 second on costs. The Dr. Proctor cost specifically. He's a repeat witness in many, many cases. Again, goes to the point of that this is not novel, complex stuff. But I want to be clear, the retainer fee was not charged against. It was a sign-up fee, $10,000 before I walk in the door. If just saying that we needed to pay him that because he requested it, next time it could be $20,000, it could be $50,000, $100,000. There needs to be actual findings that it's necessary from an extraordinary expense as opposed to just, well, he asked for it, so they had to pay it. And we would ask this court with that to reverse. Thank you.
Thank you, counsel, for your respective oral arguments this morning. This includes our oral arguments for this morning. We stand adjourned.
All rise. Good today?